morning, madam. Today we are going to discuss about the workplace bullying and violence in Malaysia. Bullying at work involves repeated negative actions and practices that are directed at one or more workers. Bullying is an issue in the workplace. Based on research, workplace bullying has become a common challenge. There are nearly 70% of Taiwanese employees have been victims of workplace bullying. How about Malaysia? Employees who work in customer service would get bullied, especially younger and new employees. Based on research, there are 81% of Malaysia employees are being bullied by someone withholding information that affect their performance. There are 82% of employees are being bullied by someone by spreading gossip about them, and 82.3% which given tasks with unreasonable deadline. Effectively control and prevention of workplace violence are imperative. They are important tool to use, which is legal mechanism.
Okay, let's now we discuss about literature review. According to Aslinda, she pointed that the bully will uses the victim persona problem as bullying materials to attack the victim's back instead of in front. Okay, researchers show that health, effect, and treatment are the important factor in this definition, which are of others in a less prioritized manner based on few benches. Another research also showed that the two elements of the multiple definition of bullying, which are continued behavior and unique power relations. And the other author, Salin, shows that the conceptual taxonomy is explaining the workplace bullying. In this classification scheme, there are three interrelated structures, which are support structure or antecedent, motivate structure or motivation, and promote interaction, promote process or trigger conditions. And the other author, Ho, he shows that the classification is based on conceptual model, assuming that the organizations plays a bullying role in three areas, which are enabling, motivating, and triggering. And this example case is in MST Industrial System as Danny Berhad versus Fuchilik. The claimant had tendered his resignation and later maintained that he was forced into resigning and that he had therefore been constructively dismissed. The court rejected the claim on the ground that the pressure the employer uses must be repudiatory in nature in order to entice the employee to resign and claim constructive dismissal.
Next is Malaysia law against workplace bullying and violence. Penal Code Act of Violence can be classified as criminal act and non-criminal acts. One of the cases is employee attack employer with sticks in an attempt to harm him or her, then it is criminal case, and use of penal code is relevant. Case of violence in the workplace does not fall within the scope of the penal code. In this case, female employees who are sexually harassed by male employees. Such behavior is form of workplace violence. Penal code does not apply in this. Section 509, the Penal Code, is a criminal offense to insult any woman, and insulting people are silent. Under Employment Act 1955, workplace bullying and violence are considered as misconduct. The Act has applied to punish employees who committed misconduct in workplace based on Section 14(1). Employment Act interprets the word misconduct as silent, explain it are largely advantageous as it helps to cover a wide range of misconduct, including act of violence at the place of employment. Section 14(1) doesn't specify among the due inquiry or how an inquiry should be conducted. Domestic inquiry, if done properly, can amount to due inquiry under the law. In this case, employee who has no clue about how to conduct domestic inquiry could bring a serious consequence, because failure to conduct an inquiry properly if employee make a wrongful dismissal claim lead to unfavorable finding in industry court. In order to allow employees to protect themselves, employer can conduct their domestic inquiry to help them decide whether to commit misconduct.
So next I will present about the employer legal responsibility for workplace bullying and violence. Based on the common law, employer legal responsibility is to ensure the safety, health and well-being of employees and provide working environment that suits its physical and psychological needs. Prohibitions of harassment and personal harassment is considered as bullying. Based on research, Malaysian employers are obligated to make a clear written harassment policy and to ensure that employees take the initiative to avoid such violations. Policy guidelines provide in-depth advice.
So next is about the employee rights against workplace bullying and violence. For the employer, common law duty is to make sure the safety and health of the employees, but employees also need to protect themselves. So both of the employees and employers have to work together to ensure the safety and health in workplace. It is based on the Occupational Safety and Health Act 1994, which is the OSHA 1994. Then, employees need to know how employer deal with workplace bullying or violence. First is observe the bullying patterns and confront of bullies. Employer must stop the people always bullying his or her target. Employer can contact with the bullying victims in order to help them solve the problem. Second is record everything about the incidents, like bullying's name, victim names, and witness. Third is gather the witness. Maybe it's victim colleagues. They will become the reference. The fourth is the conduct a meeting that involving bullies, victims, witness, and also HR representative. This is for employer to present the case and also the evidence before doing any conclusion, maybe like dismiss the bullies. Fifth is follow up. If the bullying still exists, employer now have the right to dismiss the bullies. But before deciding on a dismissal, be sure to gather all evidence if an employee is dismissed for bullying reasons. He or she will claim for the wrongful dismissal. Based on Section 20 in the Industrial Relations Act 1967, employee must do complaint wrongful dismissal within 60 days that start from their dismissal day. The case does not end immediately in the industrial court. If the employer and employees is broken because of the workplace bullies, then the employees can resign and claim the constructive dismissal. In Malaysia, the term of constructive dismissal refers to an act that employee in terminating he or her employment due to the employer's violates the contract of service. The common law always recognizes that employees have right to terminate their contract because the employer misconduct like workplace bullying. Employee fail to ensure that conditions are met could result the resignation not meet the criteria for the constructive dismissal and lead the court to dismiss the claim. So the last is beside that, based on the Employment Act 1955, Section 7, Sub 3, employee can terminate the service without notice due to the dangerous threats like bullying happen in workplace. So there are the rights and the legal information that employees need to know about the workplace bullying.
Next one, I want to present the global trend of workplace bullying and violence. In South Africa, workplace hostility are abnormal high. In 1998 and 1999, Internet surveys indicate 78% survivor has experienced bullying. In USA, violence is a major contributor to death and injury at workplace. In 1999, violence was most important security threat to America's largest corporations, according to the 1000 Security Executive interview for the annual Pinkerton. In the European Union's survey based on 21,000 face-to-face interviews with workers throughout the EU indicated that 2% workers subjective to physical violence from people belonging to their workplace, 4% people subjective to physical violence from people outside their workplace, and 2% people subjective to sexual harassment. Under the wrongful dismissal for workplace bullying, we found out 2 cases. First one, Stone v. Lancaster Chamber of Commerce. The tribunal unanimously upheld Mr. Stone's claim constructive dismissal after she was bullied by manager Paul. It deemed the dismissal manifestly unfair and judgment ran to 17 pages. Another cases that we use is Kammer v. Unison. Miss Kammer was employed as Unison regular officer. She claimed constructive dismissal, breach of contracts, and wrongful dismissal because she has faced 2 years of unreasonable treatment from the manager.
In conclusion, workplace bullying and violence is a health and safety issue. Both employees and employer need to have basic common law knowledge against workplace bullying and violence in order to prevent the problem increase. Thank you.